The subcommittee will come to order, and good morning to everyone. And I'd like to extend a special welcome to our witnesses and everyone joining us here today. And I do see many old and close friends in the room today, and I want to welcome you to this hearing. Our purpose today is to assess progress on the unfulfilled British commitment, a broken commitment unless the British government reverses its current course in the Pat Finucane collusion case, and how this affects the peace process in Northern Ireland. In connection with the Good Friday Peace Agreement, the British government promised to conduct public inquiries into the Finucane and 3 other cases where government collusion in a paramilitary murder was suspected. Subsequently, the British government backtracked in regard to the Finucane case, the 1989 murder of human rights lawyer Patrick Finucane. The British backtracking came despite the recommendation to hold an inquiry, which again the British government agreed to abide by, of the internationally respected jurist and former Canadian Supreme Court Justice Peter Corey in 2004. At this point, I'd like to thank Judge Corey again, who testified about his recommendation at a congressional hearing that I chaired in May of 2004. That is now 9 years ago, and we are still trying to get the British government to live up to its commitment. The Finucane family has testified at many hearings. Geraldine, Patrick's widow, and his son John, Michael Finucane, who is testifying today, first testified before Congress on this in 1997 in a hearing before this subcommittee, so that is now 16 years ago. And of course, there have been many others, and all of these witnesses, advocates, and experts have advocated a full, independent, and public judicial inquiry into the police collusion with loyalist paramilitaries responsible for brutally murdering Patrick Finucane. Over these years, the dedicated human rights activists and experts have established much of what has happened, and after facts have been established, the British government has acknowledged many of them. In 2011, the British government admitted that it did collude in the Finucane murder and apologized for it. Much of the credit for this admission goes to the many of you who have done the work, the hard work, on all the reports that documented collusion until it was pointless for the British government to continue denying it. So that is progress, but the work is not done because the British government has reserved one final, yet massive injustice. It continues to protect those responsible for the murder of Patrick Finucane. Prime Minister Cameron told the Finucane family that the government would not conduct the promised public inquiry into the collusion. The deliberate decision not to proceed with the public inquiry is a glaring public breach of faith. It is a source of enormous frustration to Patrick Finucane's family and friends. It resonates throughout Northern Ireland, calling into question the British government's commitment to peace and reconciliation, and above all, justice. This is particularly sad because the British government has taken so many other positive, truly honorable steps. Many of them were painful for large sectors of the British public and public opinion, such as the Bloody Sunday inquiry released in 2010. To call all of that into questioning by reneging on the promised Finucane inquiry is a tragedy. It's a preventable tragedy, however. Most recently, in December of 2012, Sir Desmond de Silva released a new report on collusion in the Finucane murder, really a review of existing case files rather than the gathering of new evidence that the promised inquiry would produce. The de Silva report detailed what Prime Minister Cameron admitted were shocking levels of state collusion. Let me repeat that. The de Silva report detailed what Prime Minister Cameron admitted were shocking levels of state collusion in the murder, including that it was RUC officers who proposed the killing of Finucane, passed information to his killers, and obstructed the investigation, and that British domestic security had intelligence of the murder threats months before the actual crime, and yet took no steps to protect him. It is admirable that the Prime Minister has admitted collusion and apologized for it, but it is really too much to admit a government crime and then say it will not be investigated, particularly when the government has undertaken a commitment to do so. The question asks itself, after so many positive steps, is the British government really going to diminish the good it's done since 1998 in order to protect the identity of people who share responsibility for a brutal murder? At this moment, I'd like to say that I will be asking members of Congress to sign a letter to the Prime Minister urging him to conduct the promised inquiry. Many members of Congress have repeatedly called for this, including the passage of 2 of my congressional resolutions, H.Res. 740 in the 109th Congress and H.Con.Res. 20 in the 110th Congress. I now would like to yield to my friend, Mr. Weber, for any comments that he might have.
Thank you, Mr. Chairman. I appreciate you holding this hearing. In the interest of time, I'm going to limit my remarks and say, let's get going. Thank you.
I'd like to yield to friend and colleague, Richie Neal.
Thank you, Mr. Chairman. Thank you for using your committee assignment to keep this issue in front of the American people. I have, as you know, for decades pursued many of these cases. A reminder today of how we've been vindicated in many of these instances. Guilford, Birmingham, Joe Dougherty, the deportees, and of course, Bloody Sunday. For those that question the efforts that many of us have made over these years, I would remind all of the conversation I had with those families when Prime Minister Cameron took to the floor of Commons and apologized for what had happened on Bloody Sunday. I talked to those families within hours of that apology. The joy that overcame them, the tears with which they greeted me on the phone, indicating that but for America's interest, many of those cases perhaps would not have been brought to light. Those families knew full well that none of their loved ones had been involved in triggering the events of Bloody Sunday, as was the case with the other examples I've already noted. I've known the Finucane family for a long, long period of time, and Geraldine Finucane deserves the full inquiry that was once promised by the British government. I've spoken with various British prime ministers, secretaries of state, and other senior officials for many years. A full inquiry would bring about justice. And let me also say, so do the families of Rosemary Nelson, Raymond McCord, Robert Hamill, and Billy Wright. We note today that there has been great progress, as I heard from you on the way in. Various British prime ministers have certainly changed the tone of the conversation over these years, and indeed we should all be very grateful. But much of the incentive came from the American people, who demanded that these inquiries be fully accepted and introduced. But the Finucane family deserves more than an apology. They deserve the full and independent inquiry that was promised earlier by Prime Minister Blair and what we thought was going to be a position adopted by Prime Minister Cameron. Recent evidence indicates that this inquiry is needed now more than ever. Prime Minister Cameron and many of his advisors have recently disclosed correspondence that certainly makes clear what should be taking place. Jeremy Haywood has described the killing as, quote, far worse than anything alleged in Iraq or Afghanistan. And I've offered a letter that I know my colleagues will sign, urging Prime Minister Cameron to hold the full inquiry that was once promised. We know there was collusion in this case. Now we have to find out who was responsible. The changes that we've all had a chance to witness in these it'll-never-happen moments have been extraordinary. But much of that impetus has come from members of the United States Congress as we've pursued these inquiries. These were sectarian, brutal assassinations. And in particular, the Finucane case is, in my mind, one of the most egregious, largely because of the manner in which it was undertaken, in full view of his family on a quiet day when all security forces and members of the RUC at the time were removed so that this assassination could take place. And I appreciate the fact, Mr. Chairman, that you have used, again, your committee assignment to keep this matter in full view of the American people. And I'm currently co-chairing a get-together at the Ways and Means Select Committee on Revenue. So I departed there to get over here, and I did want to thank 2 of my friends here from the Finucane family and General Cullen, who's been a great advocate on our behalf all of these years. So thank you very much, Mr. Chairman.
Thank you very much for joining us, and thank you for your fine work over these many years. Mr. Crowley.
Thank you, Chairman Smith, for holding this hearing. You have been a stalwart wall and someone who's not let rhetoric get in the way of justice on this particular issue, on many issues, but especially on this particular issue. I've had my own experience, many years of following this case in particular. I know it is also an issue that Mr. Neal has dedicated a great deal of time to as well. So this has been very, very bipartisan. What happened to the Finucane family is something that never should have happened. It wasn't right then, and it's not right to cover up what took place now. The fact is we're here today because of unfulfilled promises by the British government. The British government committed to a full and independent inquiry into cases of collusion, but that promise was not and has not been kept. This is a problem for many people, including those of us who supported wholeheartedly the Good Friday Agreement. I'm very much a believer in the agreement. I've praised all parties for taking risks to make that agreement a reality, and that included and does include the British government. That was a landmark agreement because it was one that has worked. And I want to do everything possible to protect the agreement and keep the peace. I believe there can be no turning back from the Good Friday Agreement, although there are many who would like to do just that. Part of that, however, is honoring the commitments of Good Friday as well as the follow-up agreements at Weston Park and elsewhere. When the British government committed at Weston Park to carry out a full inquiry, we believed that they meant it. They shouldn't back away from it now. I don't have real questions today for the panel. I'm here for the Finucane family, and I'm here in the search of justice. I agree that Prime Minister Cameron needs to call for a thorough, full, and independent inquiry into the murder of Patrick Finucane. Nothing short of that will be acceptable to people who are seeking justice in the north of Ireland and, quite frankly, around the world. So, Mr. Chairman, once again, thank you for your dedication to this particular issue, and to the ranking member as well. Thank you for inviting me to be here. So, thank you.
Mr. Crowley, thank you very much for your statement, for your leadership over these many years. And as you pointed out, this is an issue on which there is total bipartisanship and an agreement that this is a matter of justice. And justice delayed is justice denied, but my deepest concern is justice delayed in perpetuity is an outrage. Ms. Bass.
Thank you, Chairman Smith, for holding today's hearing on the recent developments in the murder of human rights lawyer Patrick Finucane. I understand that you and a number of our colleagues have continued to advocate for greater accountability and a sincere public apology in the days and years after Mr. Finucane's death. I hope that today's hearing increases awareness among our colleagues and leads to a truthful accounting of that fatal evening. And to Mr. Finucane, let me offer my deep appreciation to your commitment to participate in this hearing and your tireless efforts to keep the memory of your father alive and in the public eye. Your courage and strength are apparent, and you make your family and the memory of your father proud. I yield back my time.
Thank you, Ms. Bass. I'd like to now introduce our two very distinguished witnesses. First, we'll hear from Michael Finucane, the son of Patrick Finucane. Michael was there along with his mom and two siblings. And I would note parenthetically, we all know that his mom, Geraldine, was wounded in that horrific attack when assassins entered the Finucane home and took his father's life. Today, Michael is a solicitor in Dublin with his own legal practice. He has been deeply involved in the Finucane family's efforts to secure the full, independent public judicial inquiry that was promised in 2001 by the British government. We are grateful for your presence here today, Michael, and to tell us about where we are in the quest for justice in your father's case, which of course has a direct impact on the quest for peace and reconciliation in Northern Ireland. And without objection, your full resume will be made a part of the record, and that of our next speaker as well, because then we'll hear from Brigadier General, retired Jim Cullen of the U.S. Army Judge Advocates General Corps. In addition to his military career and career in private law practice, Mr. Cullen has been involved for many years with human rights groups focusing on Northern Ireland, including the Brehon Law Society of New York, of which he served as the first president. Welcome to General. Mr. Finucane.
I would like to offer my sincerest thanks to you and to all members of the committee and members of Congress who have supported my family this many years. I've submitted a longer statement which I'd ask will be read into the record, but I'm going to make a shorter statement for the purposes of this hearing. As is now a matter of public record throughout the world, Pat Finucane, my father, was a lawyer practicing in Northern Ireland during the period of civil conflict. He specialised in criminal defence law and developed particular expertise in defending people charged with offences under the emergency laws. As a result of his innovative approach to his work and the successes that flowed from it, he became a target for loyalist paramilitary elements who perceived him as partisan and an enemy of the British state. This much has been known for some time as a result of incidents that took place during Pat's lifetime and some of the evidence that has been revealed since his murder. We now know that this perception of Pat Finucane as being sympathetic to his client's beliefs and even that he engaged in unlawful activity on their behalf was fostered actively by the British Security Service MI5, encouraged by the Royal Ulster Constabulary's Special Branch, and known about by the British Army's undercover unit, the Force Research Unit. These agencies of state sought to besmirch Pat's name and professional reputation, to encourage support for the claim that he was a member of the Provisional IRA or working on their behalf, and to encourage the notion that he should be assassinated. We know, beyond any doubt, that all of these agencies were aware that Pat's life was in serious danger on at least 3 occasions before he was murdered, but they decided not to warn him. We know this, and much else besides, as a result of the review recently conducted by Sir Desmond de Silva QC, who was appointed by the British government in 2011. It is this review that provides the impetus for this hearing, although the work of de Silva is not what was originally promised. A comprehensive mechanism was promised by the British government to investigate the case of Pat Finucane, but it has not yet been delivered. The case was supposed to have been the subject of a public judicial inquiry, but the British government has declined to establish one, despite agreeing to do so during negotiations as part of the Northern Ireland peace process in 2001. In the 24 years since the murder, my family and I have campaigned relentlessly for a public judicial inquiry into the circumstances. In the earliest years, we were met with denial and refusal by the government and were told that accusations of collusion between the state and loyalist paramilitaries in the murder were without foundation. For example, in January 1993, the Northern Ireland office went so far as to write, in response to a draft report prepared by the US Lawyers Committee for Human Rights, that their analysis, quote, scarcely justifies your conclusion that there is sufficient evidence of the security forces' prior knowledge of the murder plot and encouragement of it to justify an independent public inquiry. They went on to say, the shortcomings of the draft report are such that in its present form it is not capable of being constructively amended. The RUC responded similarly by saying, a particularly serious disservice is done to the agencies responsible for the administration of justice and law enforcement. It is now clear that these responses from the various agencies, police, intelligence, government and army, were nothing less than blatant lies. The state was clearly culpable in the murder of Pat Finucane. Documentary evidence exists to prove this. The state simply could not afford to admit to its involvement in a crime as heinous as the murder of one of its own citizens who was, at the same time, an officer of its own courts. We now know this so definitively, partly as a result of the review carried out by Sir Desmond de Silva and the material he caused to be published, and the work of many others. It is clear now that the British state agencies knew Pat Finucane was a target for many years before he was killed, but decided not to do anything to warn or protect him. Although Pat was murdered in 1989, his life had clearly been in serious danger as far back as 1981. various agencies were aware of the threat, including the police, the intelligence services, and British Army intelligence. Documents have been published to reveal meetings took place to discuss the threat against his life, and an official decision was taken not to warn him that a murder attempt was imminent on more than one occasion because it would have exposed an informant to an unacceptable level of risk. These are just some of the facts behind the murder of Pat Finucane. Until now, they have not come to light. But the strength of suspicion over the case, a suspicion that was proven to be completely justified despite official denials, demands a comprehensive response. In the absence of any other appropriate mechanism, a public judicial inquiry became the demand my family made. It was resisted for many years until, in 2001, during peace negotiations, the British and Irish governments agreed to establish an inquiry into the case if an independent judge of international standing recommended that there should be one. That judge was former Judge Justice of the Supreme Court of Canada, Peter Corey. He recommended a public inquiry in 2004, following the publication of a lengthy and comprehensive report. Thus began a long process of delay and further denial by the government as, faced with the honouring of their promise of an inquiry, they welched. Much time passed, but then in 2011, a decision was taken by the current government as to the manner in which Britain would finally address the case of Patrick Finucane. It would not be through the mechanism of a public inquiry, despite the earlier promise to hold one. Instead, a review of the papers in the case would take place, and a government-appointed lawyer would be installed to scrutinise official documents and produce a report. My family would not be permitted, and was not permitted, to see any of these documents prior to publication, nor would we be allowed to hear witnesses called to give evidence or ask any questions. In short, we would be allowed to do nothing more than accept the findings of the reviewer without being able to assess any of the evidence for ourselves. My family was invited to 10 Downing Street in October 2011 to be told that this review process was to be established. We had been in discussions, which we had entered into in good faith, with the government for over a year prior to this visit. When we were invited by the Prime Minister to come to Downing Street, we expected to be told that the commitment given previously would be honoured and that a public judicial inquiry would be established without further delay. We had always known that the promises of the government should not be regarded as gospel. However, we dared to believe in the possibility that, with the onset of peace in Ireland, the British government might make good on its commitment. Not only were we proved wrong in this, we were forced to endure a process of public embarrassment that was cruel and unnecessary. It has been long believed that the issue of British state collusion with loyalist paramilitaries was a deep-rooted and officially sanctioned policy of selecting targets based on their degree of opposition to the state. The more troublesome the individual, the more likely the state was to deploy its killers by proxy to erase the problem. If the report of De Silva has any value at all, it is to be found in the extent to which it confirms, beyond any doubt, that this was the approach of the British state in Northern Ireland, certainly throughout the 1980s and possibly beyond. A lawyer like Pat Finucane, who was much too effective at his job for the state's liking, would make himself a target for reprisal. The extent of collusion was therefore such that the state could kill anyone it wanted to with complete and absolute deniability. This was the policy of collusion, a modern Irish Holocaust. The one question that has not yet been answered is, how many perished as a result of it? Certainly, Pat Finucane was not the only victim. Perhaps the most succinct description of the case to emerge in recent years was contained in a letter written by a senior British security advisor to the current Prime Minister David Cameron. This has only just been made public as a result of court proceedings, and it was written July 2011. The advisor said, "Even by Northern Ireland standards, the facts are grisly. Moreover, in terms of allegations of British state collusion with loyalist paramilitaries, this is the big one. Exhaustive previous examinations have laid bare some uncomfortable truths. Paid agents were directly involved in the killing, including the only man ever convicted of involvement in it. The conclusions of Lord Stevens paint a picture of a system of agent running by the RUC Special Branch and the British Army's Force Research Unit that was out of control. He went on to say, some of the evidence available only internally could be read to suggest that within government, at a high level, this systematic problem with loyalist agents was known, but nothing was done about it. It's also potentially the case that credible suspicions of agent involvement in Mr. Finucane's murder were made known at senior levels afterward, and nothing was done. The agents remained in place. He concluded in a follow-up letter by saying, this was an awful case and as bad as it gets, far worse than any post-9/11 allegation. This is the summary of a security advisor from within the British establishment. The contents of his letters were not public until a recent court hearing in Belfast brought them to light. We have had to resort to litigation against the government in order to force them to reveal information of this nature and to establish the public inquiry we were promised. We should not have to do this. We should be reading the material in the context of a public inquiry, the one that was promised in 2001 and the one that has been required since 1989. On behalf of my family, Mr. Chairman, I ask for the support of this committee, the support of the House and all of Congress, to use its influence and to persuade the British government to honour its long-standing promise to establish a public judicial inquiry into the murder of Patrick Finucane. Thank you very much.
Mr. Finucane, thank you very much for your extraordinary work over these many years on behalf of your father and that of your entire family, because not only are you seeking justice for an individual brutally slain, assassinated right in front of your own eyes, but this is also a very important symbol for peace, reconciliation, and above all, justice. And you have done an incredible credit to your father's memory and your other family members as well for keeping this front and center before the world. So thank you so very much. General Cullen.
Smith, and also members of the subcommittee for this opportunity to appear before you today. My name is Jim Cullen. As the chairman mentioned, I'm a retired Brigadier General of the U.S. Army Judge Advocate General's Corps, and last served as Chief Judge IMA of the U.S. Army Court of Criminal Appeals. I first met Pat Finucane when he came to the United States to serve as an expert witness in a political asylum case. And I just wanted to mention today my interaction with one of the men involved in the murder of Pat Finucane. An interested group in New York put an ad in the Belfast Telegraph, the main unionist newspaper, offering a reward for information about Pat's murder. To my surprise and their surprise, we received a call within a day after the reward notice was posted. And we arranged to meet the following weekend in a hotel outside of Dundalk, near the border in Northern Ireland, with the person who was represented to be part of the team that killed Pat. When we met, the person who called me introduced me to William Stobie, who was otherwise known as Billy. There was a preliminary discussion about the confidentiality of the meeting and the terms of the reward, and I explained to them that we were not after information about the Loyalist killers themselves. We had fairly good indications about who they were. Rather, we had received information from the UK that the murder had been commissioned by two upper-level officers in the police special branch, and it was information about them that we sought. Mr. Stobie went on to speak to me for about 2 hours. He very credibly said at the outset that he would not have been trusted with information about the special branch, even though he knew that the terms of our reward offer was dependent upon that information. He explained that he had been recruited by the UDA, one of the Loyalist death squads, to be their armorer and quartermaster in a section of Belfast. He had served in the British Army for about 6 years, and he had been trained as an armorer, that is, a person who is trained to fix light weapons. He had run up a debt in a Loyalist drinking club, and they gave him a choice he could either become their armorer and safeguard and store their weapons, and the other alternative wasn't so pleasant. Now, not long after he was recruited by the UDA, he participated in the murder in 1987 of an innocent young Protestant student, Brian Lambert, who was mistaken for a Catholic. Soon after that murder, he was approached by the Special Branch and recruited to be their agent, with the understanding that nothing would happen to him for Brian Lambert's murder. A co-actor in the murder was prosecuted. Stobie was told about 2 years later, on or about February 6, 1989, to have 2 pistols ready to deliver for an operation the following Sunday. He said the UDA told him that the target was a quote-unquote top provo living in North Belfast, but he was not told the identity of the target. He said he called his Special Branch handlers the very same day and related what he had been instructed to do by the UDA, including the location of where he was to deliver the weapons the following Sunday morning. He later contacted his Special Branch handlers in the week following, he thinks on Wednesday, and they confirmed that he was to go ahead as instructed by the UDA. The following Sunday morning, he went to a Loyalist drinking club quite early in the morning, and as he pulled up, he noticed parked across the street from the entrance to the drinking club an unmarked car in which sat one of his handlers, and there was another man in the car whom he didn't recognize. He went into the club and turned over 2 pistols to the hit team near the exit of the club. He emerged from the club, went to his car. He was followed out by the hit team. He waited until they left, and he followed them out. And then he noticed something quite strange. Instead of the unmarked police vehicle following the hit squad, they made a U-turn and went in the opposite direction. He went home, and then he had the radio on later that evening, and he heard about the murder of Pat Finucane. He knew immediately who had been the target for the operation for whom he had been instructed to provide the weapons. Stobie was contacted by the UDA on the following Tuesday after the murder, and he was told to dispose of the weapons in accordance with some instructions he was given. He picked up the 2 weapons where they had been left for him. He called the Special Branch and told his handlers that he had the hot Browning, he misidentified it as a Heckler 9mm, which was the principal weapon used in the murder. Special Branch told him to follow the UDA's instructions, and they sent an unmarked Land Rover to meet him. He and the Special Branch man drove to the Ardoyne area and were followed by a helicopter. He didn't know whether it was Army or police helicopter, who were watching the vehicle as it proceeded. When they arrived, Stobie gave the weapons to a man he called David Anderson. Stobie told me that he realized the UDA began to suspect he was an informer. And then in 1992, he was shot several times. Inconveniently for the UDA, the Special Branch, and the Army, he survived. He was visited in the hospital by a UDA boss who told him it had all been a mistake. Well, Stobie had sufficient street smarts to know that it hadn't been a mistake, and he decided he needed to acquire an unconventional life insurance policy. So he approached a newspaper reporter, told him his story with the expectation that the reporter wouldn't say anything, but after he told his story, this particular reporter told him he had just accepted a position as the chief press officer of the Northern Ireland office. So Stobie then realized he needed a backup insurance policy, and he went to his second reporter, again related the story with the understanding that nothing was to be disclosed unless Stobie gave permission or unless something happened to Stobie. He then let it be known to some of his UDA acquaintances that he had made, quote-unquote, arrangements in case anything happened to him, and he thought he would be okay. It was that second reporter who contacted me in response to the reward notice. Thereafter, the police planted 2 pistols in his mother's home. He realized that he was, to use his term, being stitched up or framed to get him out of the way. He also realized that if that effort wasn't successful, he was likely to again be a target because Lord Stevens had begun his 3rd inquiry in May of 1999. And Stobie quite rightly figured that the special branch, the Army Intelligence Unit known as the FRU, and the UDA saw him as a weak link. He did have a drinking problem, and they figured if an investigation began, he might talk. So Lord Stevens did confirm in his 2003 report that he did identify Stobie as a person of interest very early on in his investigation. Stobie saw our reward as an opportunity for him, his wife, and his mother to start a new life in Canada, and that's why he wanted to talk to us. When I told him we could only pay the reward if we had the information about the special branch handlers, I suggested to him that if he knew somebody else who was involved who would have that knowledge, we'd pay the reward. We didn't care how they whacked it up among themselves. I gave him $2,000. I gave it to his attorney in his presence as a good faith demonstration that we were prepared to pay the money, as we were. Stobie was later arrested as a result of evidence gathered by the Stevens inquiry, but the case against him collapsed in November 2001 when a key witness, that first reporter, claimed that he couldn't testify because of problems in his own mental state, and I can just imagine what those problems were. And then on December 12th, 2001, Stobie was murdered by the UDA. They were successful this time. And this was after he had made it known that he would be willing to testify in an inquiry into Pat Finucane's murder. He stated that he would not name the loyalists involved, but he was prepared to name the police handlers, or at least their code names, because he didn't know even the real name of his own handler. In a statement made by a masked paramilitary after his killing, it was claimed by the paramilitary, Billy Stobie could have stayed on the Shankill and been left alone had he not spoken out on Ulster television and backed the public inquiry into Pat Finucane's killing. Clearly, it was the police special branch and the Army Force Research Unit who were really worried about the possible impact of Stobie's disclosures. The prior knowledge of the special branch and the FRU about the murder, together with the unquestioned coordination of those 2 branches, because you cannot run multiple intelligence operations in the same theater without having coordination at the top. There's going to be turf wars, there's going to be issues over who controls what intelligence assets, so we know that the head of special branch and the head of military intelligence in Northern Ireland were members of a so-called task coordinating group. They in turn reported to the Joint Intelligence Committee in London. These kind of operations just didn't happen by some cowboy being out of control. It was coordinated. And today we're faced with the situation in which faceless securocrats and their political protectors have successfully neutered the rule of law in Northern Ireland and have sadly intimidated the current political leadership in the UK. Thank you, Mr. Chairman and members of the committee.
General, thank you very much for your very extensive work and testimony today. It is greatly appreciated by this subcommittee. I have a couple of questions I'd like to start off with. You know, there's no statute of limitations, as we all know, on murder cases. Even in cases of Medgar Evers' murder and the Birmingham girls that were firebombed, causing 4 girls to lose their lives, they were reopened, retried years later due to continued investigation. I would note parenthetically that Evers was murdered in front of his family in a way that is very similar to and parallel to Patrick Finucane's murder. So this, it seems to me, is a very disturbing bit of unfinished business. The public inquiry certainly would bring a great deal of scrutiny and light to something that has suffered nothing but shadows and an occasional breakthrough. And it does beg the question as to why the cover-up. Who are they protecting, as I think all of us are concerned about? My question, I guess, to both of you would be, in Judge Corey's report on Patrick Finucane's murder, he asserted that without public scrutiny, this is a quote, doubts based solely on myth and suspicion will linger long, fester, and spread their malignant infection throughout the Northern Ireland community. Do you agree with his assessment? And is this ongoing cover-up harming the British government's credibility?
Yes, I would agree with the assessment. Judge Corey concluded, as he did, and others who have looked at the case reached the conclusion that not only was the murder of my father as a result of the work that he was doing and the successes that he had, but also it was meant as a warning to other lawyers that if they attempted to replicate his successes or employ the same techniques or seek the same successes in the courts that he sought and achieved, then they might meet the same fate. Not only did it represent an attack on the rule of law and the position of lawyers as defenders of their clients, but it also compromised the ability of people to achieve their right to an effective legal defense, because lawyers had to now consider, defense lawyers for the first time, now had to consider whether they would be putting themselves or their families at risk by accepting work that was politically unpopular. And my father was prepared to do this. My mother, I think, said it best in the immediate aftermath of the murder that, you know, Pat was a professional to such an extent that he would have represented the people who shot him. So fervently did he believe in the rule of law and the value of maintaining a commitment to the rule of law, even in the face of civil conflict. So I think the murder definitely had that dimension to it at the time. The ongoing effect of the killing, the surrounding circumstances, the evidence that has come to light, and the broken promise given by the British government at Weston Park is to elevate the case to a highly iconic status that is capable of being abused as a propaganda tool by people who might seek to continue the conflict. I do believe and fear that that is a risk. And it is also damaging to the British government because, quite simply, they didn't keep their word. And if a government is seen as not being capable of keeping its word or acting honourably, well then, it doesn't deserve to be a government. It is clear from some of the information that has come to light as a result of the recent litigation in Belfast that the decision not to hold a public inquiry by the Cameron administration was one hotly debated within the civil service. So even within the British establishment, the danger of going back on their word, of breaking the commitment, of welching on the promise given in Weston Park was recognised and understood, and many British civil servants, including the Cabinet Secretary at the time, argued against it and expressed a lot of surprise that the Prime Minister was going down this road.
General.
One of the surprises to me after witnessing that the Prime Minister went ahead in publicly addressing the Savile inquiry, and I had occasion to speak to the Secretary of State of Northern Ireland about our experience with the My Lai massacre, in which I represented the chaplain in the Peers Commission inquiry after the massacre, and how it was necessary to redeem ourselves as an institution, and I'm talking the military at that time. We had to reveal what went wrong, withhold nothing, and then trust to the American people to place their trust back in us again by coming clean on what went wrong and trying to make the institutional fixes. I suggested to them, and I'm not suggesting for a moment that my input played any role in the Secretary of State's view, but they did take that approach with the Savile inquiry, and the Prime Minister was applauded in the Guildhall Square of Derry when he made the announcement acknowledging responsibility. I thought that he was heading toward that same kind of a conclusion in having an inquiry. I had suspected for years that there was deliberate delay until Mrs. Thatcher passed away or was not able to appear before an inquiry, because it was her practice on occasion to sit in on the Joint Intelligence Committee, which had overall supervisory responsibility for the work of the Task Coordinating Group that ran things in Northern Ireland. That was a group made up of senior military and police officials. But I realize now that I was wrong in my assessment. I don't think it was Mrs. Thatcher at all. I think it was the security people at the top end, MI5 and MI6, and the remnants of special branch that continue in the police today, who, for whatever means that were at their disposal, whether it was some version of Mr. Hoover's infamous private file cabinet or for some other reason, were able to effectively block what I think Mr. Cameron was prepared to do but couldn't do.
You know, in your written testimony, thank you, Mr. Finucane, you say the review conducted by Desmond De Silva reveals a great deal of information for the first time, but it is nowhere near being a complete answer. It is based on a reading of documents without any questioning of the authors. Indeed, only 11 witnesses were spoken to by De Silva, and 12 written submissions were received. No former politicians were interviewed, nor were a number of key intelligence personnel, including the former head of military intelligence in Northern Ireland, who was in charge at the time of your father's murder. And then you point out, as if this is not bad enough, on the day that the Silva report was published, Tom King, now Lord King, led the public response on behalf of the government. He was the Secretary of State for Northern Ireland in 1989 when your father was murdered. You go on to say, not surprisingly, he rejected calls for a public inquiry, claiming that the matter had now been fully investigated. It is difficult to conceive, you go on to say, of someone with greater conflict of interest than the former Secretary for Northern Ireland in 1989. The dangerous suspicion that lingers around his defense of the government's position is that those responsible for the policy of collusion remain in positions of significant influence and will continue to get away with it. As a key witness at any potential inquiry held, Lord King's rejections of the calls for an inquiry merely add insult to injury. That is a very, very powerful statement. I know after the De Silva report, there were some in the Labor Party who suggested that there ought to be a public inquiry. Mind you, between 2003 and 2010, during both the Blair and Brown governments, they refused a public inquiry, but they may be seeing things a bit differently. And I'm wondering if you've heard, if you might want to further elaborate on that statement, because that it doesn't get any more powerful than that, and your thought as to whether or not there might be a reevaluation going on in the House of Commons.
The position of the opposition in the House of Commons, led by Ed Miliband, is that an inquiry will be established if they are returned to government. The difficulty that arose when Labour was in power between 2003 and 2010 was the enactment of legislation that limited the manner in which inquiries would be carried out. Ministers would have control over the information that appeared before the inquiry and in public, and that control would be an absolute discretion, not subject to input from any of the parties, and would limit the ability of the inquiry to explore important issues publicly.
If I could interrupt, so are the Labor MPs suggesting that that law would not be applicable in this case? Because I too read that law and thought it was unconscionable that the ability to veto information from becoming public would lay in the hands of the very people who would have conflict of interest potentially.
Well, that was indeed the fear.
Right.
However, since the passing of that law, the Inquiries Act of 2005, a precedent has developed since in relation to a case that arose from circumstances in Iraq, where the Inquiries Act was not implemented in full for that particular inquiry, in the case of a man called Baha Musa, who was killed by British soldiers. But instead, the decision as to what material would be withheld and what material would be disclosed was left to the inquiry chairperson, and only the chairperson. And that allowed an opportunity for representations to be made in public and some measure of debate to be had as to what information the public would see. It would not be taking place in a minister's office in the way originally envisaged under the terms of the Act. That precedent was the one we wanted the government to follow. That was the one we were discussing with them for about a year between 2010 and 2011 when the Cameron-Clegg administration took power. We expected, when we went to Downing Street, to be told that this precedent was going to be followed because, if for no other reason, we were not asking for something to be created for our case. We were simply asking them to give us the same as they had given somebody else. But that obviously was refused. The position of the opposition, as I say, is that they will establish an inquiry. They will live up to the promise of Weston Park. In terms of, but until that happens, we have to endure this U-turn by the Cameron administration. And as if that wasn't bad enough, on the day the De Silva report was released, I had to experience walking past Tom King in the BBC in London as he went into one studio saying, "I'm satisfied no inquiry is necessary now, the matter has been fully investigated." And I went into another studio saying, "Well, it hasn't been investigated, and the man in the studio next door is someone I'd really like to ask a few questions of." This is just another example of how much damage is being done to the government's credibility as a result of both its decision and its choice of spokesperson. I can't think of anything more insulting than the person who was in charge at the time, who was getting briefings from the Force Research Unit, who met some of the people in charge, who was aware of the extent of intelligence available to the state, and yet is able to get away without having to answer for his actions while in office. He said that he would have been available to the De Silva review if they had asked to speak to him, but it appears they did not. In fact, they didn't ask to speak to any politicians. And it seems to me that that is a glaring void in the process that De Silva was asked to undertake, and underlines the need for a public inquiry, because there are people who should be spoken to and should be questioned who simply have not been up until now. And we really have to start doing that before more time passes and those people become unavailable.
You referenced the impact that your father's assassination had on other defense attorneys. I would just note that on September 29th, 1998, 15 years ago, a little over 15 years ago, sitting right where you sit and where General Cullen sit, we had Rosemary Nelson tell her story, especially the death threats that she had received from the RUC, and within a year, 6 months really, she had been assassinated with collusion all over the place. So, you know, the killing defense attorneys, human rights defenders like your father, had an impact. I'm sure there were many attorneys who thought they might do this very noble work who decided to take a different path because of what had happened to your dad and then what happened to Rosemary Nelson. So this committee, I can assure you, will stay focused until and when the British government does the right thing, as they have promised to do, and that is to conduct a public inquiry, and they do need to hold people who allegedly have committed collusion or held to account in a proceeding that will bring justice even at this late date. I'd like to yield to Vice Chairman of the Subcommittee, Mr. Weber.
Thank you, Mr. Chairman. To you, Michael, and to your mom, I want to say my deepest condolences. This is, of course, I'm newly elected, so I'm kind of getting up to speed here. And so a lot of the things you're discussing and you're testifying to, I'm not as knowledgeable about our chairman here, who's done a fine job of keeping up and trying to keep the pressure on. But I've got some questions, so bear with me. If you will, and let me see if I can't get some answers. You talked about the agreement, was it the Weston Park, where the
Weston Park.
Weston Park? Tell me who made that agreement and tell me about that.
The original Belfast Peace Agreement that set out the broad structures to be put in place post-conflict were agreed in 1998 and somewhat famously concluded on Good Friday, 1998. But this was a framework document. It did not go into detail in a number of key areas. At that time, there were a number of quite fundamental structures of state and government under discussion, including reform of the police, the implementation of a new legislative assembly, and structures of local government. The Good Friday Agreement provided a blueprint for how that would be put together, but like most blueprints, it was very broad in scope. It became clear that further negotiations would be required several years later as difficulties were encountered. And
Who was in power during that time?
at that time, Tony Blair's government was in power in Britain. Bertie Ahern was the Prime Minister in Dublin, and the negotiations subsequent to the Belfast Agreement of 1998 took place in a location called Weston Park, and they happened in 2001. And a number of issues were discussed, including policing, local justice issues, the Legislative Assembly that will be set up, and so forth.
Including the assassination of your father.
Yes. Certain cases had become particularly prominent because of either suspicions of state collusion or failures of investigation by the police, allegations of police or army involvement, and so on and so forth.
All right, let me spring from that, if I could, maybe to General Cullen. And again, I'm just trying to come up to speed and catching these names and these events. You're describing a situation where there was an informant who was ultimately murdered. I think you said he had a drinking problem. So the collusion that Michael is describing by government at the highest levels here, there's going to be a circle, I'm assuming. Somebody has come in and put together a potential list of those who had knowledge or who were somehow either complacent or involved. How wide is that circle? Is it 10 people, 5 people, 100 people?
I think the collusion net is probably several hundreds of people. I would say a good part of the special branch organization were involved. Certainly the military intelligence unit, who was rebranded from time to time, but at this particular point in history was innocuously called the Force Research Unit. I think they were all involved. And the question is, how far up the political chain to whom these people reported did it go? That's one of the unanswered questions.
And my question is, so if there were several hundred back then, because of attrition or mortality or whatever, somehow that circle has narrowed.
It has narrowed through death, retirement. We don't know how far it's been narrowed. The RUC, for example, the police were both downsized and rebranded. Now, the hope was, and we've gone through this in our own history, after a conflict, we have a reduction in force or a RIF. And we use those occasions, certainly post-Vietnam, to eliminate people who were not at the highest level of their ratings. So you get rid of a lot of problems that way. We were told that the government simply would not do that. They offered significant cash packages to people in the police if they wanted to retire in order to reduce the number down. But unfortunately, what happened, I think, is some of the more capable and ambitious people saw lives beyond the police. They could take this cash package and go do what private enterprise want. Some of the bad apples, I think, stayed.
Well, I think you used the term remnants.
Yes.
In some of your earlier remarks. So, how many, without giving me names, how many, if you could interview 5 or 10 people, do you have a short list?
Oh, I would have a short list, certainly, Congressman.
Okay, and how short is that short list?
Of the people still around, I would say there's probably 5 to 10 very, very key people who were in prime positions of authority then.
Okay. So, and you made the comments that you, I think, helped in the My Lai massacre. You represented the chaplain, I think.
The division chaplain, that's right.
The division chaplain, okay. And you made the comment that said you felt at the time that for the American public, what needed to be done was all the truth needed to be out as to what went wrong.
Precisely.
And so for the American public to finally feel at peace, I guess, I don't want to put words in your mouth, but to accept and to feel like progress was being made, justice was served, that you had to come clean, so to speak.
Exactly.
What impetus does the British government have at this point to come clean?
I think the biggest thing that drives or should drive any government is to gain or to regain the confidence of its people, and especially any disenfranchised elements in its society. That would describe a significant portion of Northern Ireland, who during the course of the conflict realized that the justice system was not administered fairly, the police system did not protect people in an equitable manner. There's been huge progress made since that time. And certainly even in the worst days of the conflict, there were heroes in the police, Detective Sergeant Johnson Brown, who was one of the ones who did key work in investigating the murder of Pat Finucane, said at one point he feared far more the special branch, his own police people in the political branch, than he ever feared the IRA. And he acquired a key confession at one point that the special branch then tampered with, removing a part of the tape on which that confession was kept. So there were the ordinary people.
I'm assuming he's not still around.
He's retired now, sir, and his partner had a mental breakdown because of the threats and the stress which he was under. He's recovered, I understand, but there were wonderful people like that who at least allowed ordinary folks to say, hey, there's some good cops there who want to do their job.
Right.
But then they were painfully aware, as ordinary people were painfully aware, there were a lot of cops who didn't want to do their job.
So as a committee, as the House of Representatives, what can we do, and this is probably not the right term, but what can we do to tighten the screws, to bring a heightened awareness, to help? What can we do from across the big pond to help make that a bit more of a I don't know what the right word is, a priority? What do you think we can do?
You have a tremendous moral voice, Congressman. You are listened to across the water. And what you, in effect, can do is empower the politicians who want to do the right thing, who want to regain the confidence of the people in England, in Northern Ireland, and all parts of the UK, to say to the securocrats who are resisting a public inquiry, you must hold this public inquiry. One of the problems Michael just spoke about is there is always a danger that those who didn't want to sign on to this peace agreement, who for their own reasons would want to see this collapse on both sides, take oxygen from the failure to have this public inquiry. We have to cut off that oxygen.
Okay, one final question, Mr. Chairman, then I'll yield back, and thank you for your indulgence. Is there a window of time closing, because obviously with mortality rates and attrition, whatever, 1 year, 3 years, 5 years? I mean, sooner the better, obviously. The chairman said it eloquently, justice denied, or justice delayed is justice denied. What kind of a time frame are we on?
That's a tough question. I'd say anybody in my age range who would have been around at that time is looking at his own mortality tables, and you begin to wonder. But Stobie was murdered. Brian Nelson, a key actor, died under very mysterious circumstances. Other people have disappeared. The time is taking its toll on the justice system. And we may get to a point where even if the government were under a new government or this government in the UK decide to do the right thing, it may be too late.
Okay, thank you, Mr. Chairman. I yield back.
Could I just add one thing Mr. Weber asked about what can Congress do? By making this an issue that continues to be of concern to Congress, and perhaps communicating that where you can, but particularly to the White House, the continued contact that takes place between the administration here and that in Britain, and the notion that Pat Finucane is always going to be a subject of conversation until the issue is resolved, is the greatest moral force you can bring to bear. Perhaps starting with the letter that the chairman is circulating for members' consideration and signature, and then why not the G8 summit? That's happening in Northern Ireland in the very short future. It may not be an issue that touches on every world leader's agenda, but certainly the British and Irish, or the British and American premiers will be there. It should be a conversation happening between the President and the Prime Minister, because it is important and it's an unresolved issue. And amidst all of the problems that people are trying to sort out in Northern Ireland in 2013, problems of unemployment and so on and so forth, they've got this historical problem, a hangover from the bad old days that's not going away, but could be made to go away if the British government would simply do what it promised to do. So I think that's a real practical step that Congress can take, and it may yield great fruit.
Okay, thank you very much. Mr. Chairman, I yield back.
Very much, Mr. Vice Chairman. Let me just, I think Mr. Weber makes a very good point about, this could lead to a cold case, and by design, it could lead to a cold case. All the more reason why we need to continue our vigilance and our very energetic efforts so that does not happen. But eventually, the truth does come out over time. But it ought to come out in a way that is actionable, particularly with potential prosecutions, and certainly a public inquiry will finally lay out the information. So could you tell me, Michael, more about the ongoing litigation in which you and your family are seeking a court order to the British government requiring it to conduct the inquiry it committed to in 2001? Where is the litigation now, and how is that proceeding?
Proceedings were instituted after the decision of the British to appoint Desmond de Silva.
In what court? What venue?
In the Belfast High Court.
Belfast.
The case essentially seeks an order of certiorari, quashing the decision by the government not to hold an inquiry, and an order of mandamus requiring them to establish one. The proceedings were instituted not long after de Silva was appointed to carry out his review. We initially gave some consideration to seeking a restraining order to stop de Silva from carrying out his work, but it was felt that de Silva might conceivably disclose material that could be helpful, even though the process could never satisfy the requirements of a public examination. So the main proceedings have simply continued, and there's been the usual back and forth that you find in litigation between the government and our lawyers. But most recently, some interim hearings have taken place where we have sought discovery of documents relating to the case, including previously classified intelligence documents dealing with the murder at the time itself. A lot of those were revealed. Some of them were already public in one form or another, so they were collated during the course of the proceedings. But the government sought to withhold certain internal communications between security advisors and the Prime Minister. And the letter that I referred to in my testimony came to light only in April of this year, and the contents of it and the expressions of serious concern about the circumstances of the case and its comparison with events that have transpired post 9/11 and into Iraq and Afghanistan, and how it compares on the scale with those. The hearing took place in April. The judge hearing the case decided he would review the documents himself. So the government was ordered to supply whatever it wanted to hold back so that the judge would review them and make his decision. As I understand it, he's received those documents and we're awaiting a date for his ruling. After that, it will proceed to a full hearing on the merits and where we hope we will achieve the orders that we're seeking.
Without objection, the testimony of Jane Winter, former director of British Irish Watts, will be made a part of the record. Your full statements as well will be made a part of the record. And a submission from the government of the Republic of Ireland will also be made a part of the record. And they do, in their testimony, say quite emphatically, the Irish government will continue to seek a public inquiry into the murder of Pat Finucane as committed to in the agreements. In her testimony, Jane Winter points out that the De Silva report missed three crucial aspects in the case. One, he has misunderstood the guidance available on agent handling and its adverse impact on the detection and prevention of a crime. He has omitted to investigate the fact that British Army intelligence tampered with evidence, and he underplays the role of the intelligence service in the case. Would either of you like to comment on that?
I think in general terms, De Silva is unsatisfactory because he lays too much blame at the door of defunct organizations like the RUC or individuals who are dead or no longer available. And that's very unsatisfactory and, in our view, inaccurate. There are people he could have spoken to but didn't. There are conclusions that could have been reached, but he chose not to do so, even within the terms of his very limited mandate. And I think the extent to which he was prepared to conclude that something didn't happen because he could not see clear evidence of it is very unsatisfactory and glosses over the obvious technique of putting together various pieces of evidence and forming a reasonable conclusion based on them. He also chose to reject the evidence of some people who were involved in the intelligence services who said they saw documents and additional materials that were no longer in existence, but they were quite clear did exist at one time, including targeting information and information about my father's personal habits that was gained as a result of surveillance which we suspect was carried out either by the police or the army. The unwillingness to reach those conclusions and frustration with the process itself, that it's not public, that you can't ask questions of the people involved, that you can't assess all of the evidence and all of the documents for yourself, leaves De Silva in a very unsatisfactory condition insofar as the mechanism is concerned. It's something of a starting point, but I don't really think it can be seen as anything more than that, and it's certainly not a finished exercise.
Jane Winter makes the point in her testimony that the report, the only real value in her opinion is that it confirms collusion, vindicates Patrick Finucane, and it in itself makes a compelling case for a public inquiry. One of the findings in the De Silva report that she amplifies in her testimony is that he has confirmed that 85% of the UDA's intelligence came from the security forces. She also points out that he has shed light on the briefings given to a government minister prior to the murder. 85% of intelligence coming from security forces. If that isn't damning, I don't know what is. General?
Well, indeed, it goes back to the point I was making before. When you have intelligence operations from different entities in the same theater, you have to have coordination at the top. Right. And given the 85% number, which I read also, it did confirm to me that it was more than simple idle chat at the top. There was active coordination in not only Pat Finucane's murder, but in the murder of other innocent people.
I have one final question, and then if you would like to make any concluding remarks. What effect do you think the inquiry, according to the terms committed to in 2001, would have on the peace process in Northern Ireland?
I think the final establishment of an effective, comprehensive public judicial inquiry would address what has become the last great historical issue for the British government in the Northern Ireland conflict, certainly the most substantial one remaining unaddressed. There has been a great deal of improvement in investigative mechanisms locally. Inquests have been improved in terms of their capacity to examine killings in Northern Ireland, and there are controversial cases that have not been resolved. There are still campaigns by interest groups and relatives for a proper examination of the deaths of their loved ones, but they don't have to go for a public inquiry anymore because the domestic mechanisms, the local mechanisms have been improved and strengthened. We're left with a public inquiry because so many state agencies are involved that no other mechanism seems capable of addressing all of the issues. And we're becoming, if you like, somewhat isolated in that category because we are the last remnants of the cases I highlighted at Weston Park that required a public tribunal of inquiry type mechanism. And that's really not good. This hearing, I know, is receiving a lot of attention in Ireland and Britain. It is an issue that when matters come to light, it dominates the news headlines. When we met with, when we were in London in 2012 for the release of the De Silva report, and we're in the House of Commons, the case was front page news. Anyone saying this has gone away, or this is becoming less important, or the people feel less strongly about it, is clearly wrong. And that has to erode confidence in the rule of law in Ireland. But obviously, well, perhaps not obviously, but I do believe the opposite is true. If the British can finally grasp the nettle in this one case, in the case of Pat Finucane above all others, and really come clean and explain what went on and make the witnesses available and reveal the documents and just get it all done in one go, finally, I think the boost to confidence would be immeasurable, because I think the feeling of people on the ground is quite simple. They can't bring themselves to admit it even now. And it's hard to argue with that when you see the evidence in the case and the broken commitments. And I really think the commitments need to be lived up to. And I think the benefits, the potential benefits, are very real, and they're there for all to see.
We had tragic examples in our own country back in the 60s where civil rights workers were murdered, and there was often collusion by local policemen. But we had the FBI, we had federal courts, we had this Congress to investigate and set things straight and say that there is a rule of law and it's going to apply to everyone. That's not the case in Northern Ireland, while there is a refusal of the government to have this promised inquiry. We are ultimately talking about a government who colluded in the murder of one of its own citizens and now refuses to reveal the extent of that collusion, who sanctioned it from above. Until there is a willingness to address this in a credible way, I'm afraid there will not be the restoration of confidence in the rule of law and in the government itself, and it will give dissident factions on all sides an opportunity to say, how can you trust this government? If you got connections with the top, you can do anything you want. There is no accountability. That's unsafe for any government. We don't want to see that happen. Thank you, Mr. Chairman.
Thank you. You know, this committee, as you know, walks point on human rights. It is vested with the responsibility for the Foreign Affairs Committee and, by extension, the full House of Representatives to bring the light and scrutiny to human rights abuses anywhere and everywhere they occur, and to hopefully craft legislation that meets the needs of those who are victimized. I can assure you, both of you, and Michael, you as a son who has carried on your father's tradition as a solicitor, and has done so with great class and courage, that we will not rest until the public inquiry occurs, and we will do all within the, and I say this in a bipartisan way because there are people on both sides of the aisle who feel as passionate as I do, that justice delayed is justice denied, as I said earlier, and there needs to be a public inquiry, and it needs to be done now. And we will keep bringing our voice as a committee and individually as individual members of Congress to bear until that day occurs. If you would like to make any final, although what you just said was a wonderful concluding statement, but if you have anything further you would like to say before we conclude.
No, other than to thank you again, Chairman, and the committee members for your time and your support. I don't have anything further to add.
Thank you.
And I would just like to join in Michael's thanks for your hospitality and your willingness to hear us today. Thank you, sir.
Thank you so much. The hearing is adjourned, and we will be convening momentarily to proceed to a markup of 3 pieces of legislation, but this hearing is adjourned. Subcommittee will come to order. And pursuant to notice, the subcommittee meets this morning to mark up H.R. 1951, the Sean and David Goldman International Child Abduction Prevention and Return Act of 2013, H.R. 1897, the Vietnam Human Rights Act of 2013, and H.Res. 131 concerning the ongoing conflict in the Democratic Republic of the Congo and the need for international efforts toward long-term peace, stability, and observance of human rights. As our members are aware, these measures enjoy strong bipartisan support, and there are competing hearings and other events taking place this morning. Thus, as our members were informed earlier this week, it is the intent of the Chair to consider these measures en bloc, including the substitute amendment sent to you on Monday, offered by my good friend and colleague, Ms. Bass, and an amendment by Mr. Meadows sent to you on Tuesday. All members have copies of these documents before them, and then after we have concluded our expedited consideration, I will be glad to recognize any member, including myself and the ranking member, for any statements on the issues. All members are given leave to insert written remarks into the record should they choose to do so. Seeing that we have a reporting quorum present, without objection, the following measures are considered as read and will be considered en bloc. H.R. 1951, the Sean and David Goldman International Child Abduction Prevention and Return Act of 2013. The Meadows Amendment, number 4 to H.R. 1951, sent to members' offices on Tuesday. H.R. 1897, the Vietnam Human Rights Act of 2013. H.Res. 131, concerning the ongoing conflict in the Democratic Republic of the Congo, and the need for international efforts towards long-term stability, peace, and observance of human rights, and the Bass Amendment, number 11, to H.Res. 131, sent to your offices on Monday. The Chair moves that the en bloc items be adopted. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. In the opinion of the chairs, and the items considered en bloc are adopted. Without objection, the measures as amended are reported favorably to the full committee. The staff is directed to make technical and conforming changes. I would note that now that we have completed our formal consideration of those measures, I will recognize members for remarks, and I recognize myself first on behalf of the first bill that was just passed on to the full committee. It was David Goldman's unrelenting effort to bring his son Sean home from Brazil that first alerted me to the epidemic of international parental child abduction in this country. According to the U.S. Department of State, between the years 2008 and 2012, bereaved, left-behind parents like David Goldman reported over 4,800 abduction cases involving more than 7,000 children. I had the privilege of joining David Goldman in his fight to return Sean and experienced firsthand the maddening obstacles encountered by left-behind parents, even in countries that have signed the Hague Convention on International Child Abductions, foreign courts, endless appeals to run out the clock, exploitation of the safeguards in the convention, and prejudice against foreigners. The damage to the child and the left-behind parents is incalculable and too often lifelong. The children are at risk of serious emotional and psychological problems and may experience anxiety, eating problems, nightmares, mood swings, sleep disturbances, aggressive behavior, resentment, guilt, and fearfulness. Parental child abduction is child abuse. These victims are American citizens who need the help of their government when normal legal processes are unavailable or fail. Too many families have been waiting too long for the return of their children. Our current system, with its endless delays and lack of proper accountability, has failed far too many. It is time for the approach that backs our demands for adherence to international obligations with some penalties and makes clear to foes and friends alike that our children are our top priority. As stated in the legislation, it has several purposes. First, we want to protect children whose habitual residence is the U.S. from the harmful effects of abduction and to assist left-behind parents to have access to their abducted children in a safe and predictable manner wherever the child is located while an abduction case is pending. We want to provide left-behind parents, their advocates, and judges the information they need to enhance the resolution of abduction cases and access cases through established legal procedures, the tools for assessing the risk of abduction and denial of rights of access, and the practical means for overcoming obstacles to recovering an abducted child. We seek to provide the necessary training for officials of the U.S. Armed Forces and the Department of Defense to establish policies and provide services to parents serving in our military that address the unique circumstances of abductions and violations of rights of access that may occur with regard to military-dependent children. An additional purpose of the bill would be to establish measured, effective, and predictable actions to be undertaken by the President on behalf of abducted American children, and to promote an international consensus that it is in the interest of children to have any issues related to their care and custody determined in the country of their habitual residence. And finally, the bill would encourage the effective implementation of international mechanisms, particularly those established pursuant to the Hague Abduction Convention, to achieve reciprocity in the resolution of abductions and to protect children from the harmful effects of abduction. The Goldman Act gives the President important tools to motivate other countries to quickly respond to applicants for abducted child's return. For even one case that has been pending for over 6 weeks in a foreign country's judicial system, the President may choose to at least issue a private démarche or take more serious actions commensurate with the gravity of the case. If a country has 10 or more cases of children abducted from the U.S. pursuant to this legislation, and those cases are not being resolved in a timely manner, or the entity responsible for working with the United States, U.S. Central Authority, the judiciary, or law enforcement, are persistently failing to fulfill their obligations, the President can take measured, effective, and predictable actions to aggressively advocate for our children's return. Actions range from denial of certain assistance to prohibiting the procurement of certain goods or services from the government, or the instrumentality response for the pattern of what we call non-cooperation. The President is required to request a consultation with any government concerned and report to Congress when contemplating serious actions. The President is also provided with certain waiver authorities that take into account the important national interests of the United States. However, the expectation is that the President will use all tools necessary to bring our children home in a timely manner, and that the President will have to explain the minority of cases where one of the 18 delineated tools or commensurate action cannot be used. I want to thank Mr. Meadows for his valuable amendment to the bill, which calls on the Government Accountability Office to report to Congress on Egypt's cooperation or facilitation of parental child abduction. Last week, the subcommittee heard compelling testimony of Mr. Colin Bauer, whose 2 boys were abducted to Egypt in 2009. Mr. Bauer indicated that Egypt has aided and abetted in the kidnapping and illegal holding of his sons, including by issuing false Egyptian passports for the 2 boys and by allowing them to exit the U.S. on Egyptian government-owned airline Egypt Air. It will be very helpful for members of Congress to receive an assessment from the GAO of the Egyptian government's involvement in this and the other cases of child abduction from the United States. I yield to my friend and colleague, Ms. Bass, for any comments you might have. Mr. Burr, Dr. Burr.
Mr. Chairman, thank you for convening this markup. I'm pleased that Foreign Affairs Committee and this subcommittee is proceeding with regular order as it moves legislation to the full committee. I want to focus for one moment on H.R. 1951, the Child Abduction and Return Act of 2013. I'm pleased that the subcommittee was able to focus on this important issue, and I support many of the provisions contained within the legislation. However, I believe the State Department has expressed some concerns in a possible unintended consequence of this bill. The punitive measures offered to the President under the legislation may discourage a non-party nation such as India from signing or ratifying the Hague Convention. As this legislation moves to full committee, I would like to have a better understanding of the non-signatories and what we can do to encourage their cooperation on this important issue. It's important that these countries join the Hague Convention. I would also like to work with my colleagues to address these concerns and ensure that any legislation we pass will have the desired effect of reducing the number of child abductions. Again, thank you, Chairman Smith, for continuing your important work in this area. Congratulations on moving your legislation through the subcommittee, and I look forward to working with you on this important issue. I yield back.
Dr. Burr, thank you very much. Chair recognizes Mr. Weber.
Mr. Chairman, thank you. I don't have any comments at this time.
Okay, Mr. Meadows.
Thank you, Mr. Chairman. And obviously, this committee just acted to approve 3 pieces of timely and necessary legislation that will better the lives of thousands of people. And I'm proud that this committee has taken the initiative to address the ongoing humanitarian issues in Vietnam and in the Congo. And I want to commend the chairman and the ranking member for your leadership. The third bill we approved today, H.R. 1951, addresses the parental child abduction and the Hague Convention. This is a good bill. I'm proud to be a co-sponsor and proud to have supported it today. I'm also proud that we've been able to amend this bill to make it a little bit better. Last week, we heard powerful testimony on the foreign parental child abduction from parents of victims. And we heard that the foreign governments can often be complicit in these abductions, especially in non-Hague Treaty countries. And one of those witnesses was Colin Bauer. Mr. Bauer's 2 sons, Noor and Ramsey, were abducted and taken to Egypt in 2009. They remain there today with 20 other American children. Egypt is a country that we are working with and whose continued solvency depends on American aid and American intervention, and yet we hear heartbreaking stories like Mr. Bauer's. Thankfully, Mr. Bauer did not just share his story, but he shared recommendations on moving forward. And one of those recommendations was to require the GAO to report on the child abductions in Egypt, including the role of the Egyptian government. Today, I offer an amendment to H.R. 1951 to do exactly that, and I look forward to reading the GAO's eventual report. And I want to thank Mr. Bauer and all of those previous witnesses for sharing their stories, but I also want to thank the committee for supporting my amendment and moving this bill. And with that, I yield back, Mr. Chairman. Thank you.
Ms. Meadows, thank you very much, and thank you for authoring that very important amendment to this legislation. I'd recognize Mr. Stockman.
Thank you, Mr. Chairman, for your compassion that you've shown through all the years you've been here in Congress, and I appreciate that throughout the years you've stuck to it and when it had been easy to roll over to Ways and Means or some other important, quote-unquote, important committees, and that your compassion is demonstrated by these bills that you put forth. And I just want to say something quickly about our friends at DRC. I've been there many times, and they have a great potential. This nation's larger than Europe, Western Europe. And they have great potential if they adhere to civil society and they stick to the rule of law and let democracy flourish. And I think this bill is going to go a long ways in ensuring that the DRC will be successful in achieving its goals. And I really appreciate you offering this bill. And I hope when it gets to the full committee that they realize the work and effort that you have put into these bills. But I just wanted to point out that DRC has a great opportunity to take advantage of and work cooperatively with the United States, and look forward to future hearings and testimony. Thank you.
Thank you very much, Mr. Stockman. I yield to Ms. Bass to speak on H.Res. 131.
Chairman Smith, again, thank you for holding today's markup. I'm delighted that we've worked in a bipartisan manner to pass today's legislation, and did want to speak for a minute on H.R. 131 concerning the ongoing conflict in the Democratic Republic of the Congo and the need for international efforts toward long-term peace, stability, and the observance of human rights. As you're well aware, in the DRC, an estimated 5 million people, which is just an incredible number, have died, and some 2 million have been displaced due to repeated cycles of war, conflict, violence, particularly sexual and gender-based violence waged against women and children. It's time for this crisis to come to an end. Today's markup takes an important step forward in efforts to raise awareness within the U.S. Congress and among all Americans of this horrific and tragic crisis. I was recently in the Congo and heard from many people there, and I've heard from the Congolese diaspora here in the United States about the situation in the Congo. Currently, we have 55 members of the House from both parties that have co-sponsored this bill, and I plan to continue to call for bipartisan support for this legislation. It's also my understanding that efforts are underway to introduce similar legislation in the Senate. Lastly, there's been a great deal of discussion around the need for a special envoy to the DRC and the Great Lakes region. This legislation calls for such an envoy, and Secretary Kerry, in testimony before both the House and the Senate, has indicated his plan to make an appointment. I'm pleased that this effort is making progress and urge the Secretary to move swiftly to make his decision and develop a comprehensive strategy that relies on diplomacy and engagement to address the complex set of issues that stand as barriers to peace and stability in the DRC and the region. Thank you, and I yield back my time.
I want to thank, yield myself as time as I may consume. I want to thank the Ranking Member Karen Bass for introducing this important resolution, and I am very pleased to be original co-sponsor, and it's supported, I know, by members of this subcommittee. This measure brings attention to the continuing deplorable situation in the DRC, in which more than 24 militias, as well as the National Army itself, continue to terrorize the country's population. The international community has been outraged by the staggering rate of sexual violence, with reports of nearly 50 women and girls being raped each hour in the DRC. The atrocities also include the recruitment and physical and psychological torture of child soldiers. H-Res 131 calls on the nations of Africa's Great Lakes region, including the DRC government itself, to take all necessary actions to live up to international law and their own agreements concerning non-interference in one another's affairs. As we found out through several UN investigations and our own subcommittee's 3 hearings last year, this has not always been the case. Unregulated cross-border militia activity and the plundering of natural resources in the DRC have made life for so many Congolese, especially those in eastern Congo, all but unbearable. The trade in illicit minerals and poached ivory has also served to fuel the conflict in the DRC. The Atrocities Prevention Board, created in 2011 to coordinate U.S. policy to prevent mass atrocities and serious human rights violations, is called upon by H-Res 131 to work with regional and international partners to bring the tragedy of life in eastern Congo to a definitive end. The Atrocities Prevention Board is directed to, quote, address, prevent, and ensure accountability for serious violations of humanitarian law and human rights abuses by all actors in the DRC. While its neighbors share the blame for the international crisis that exists in the Great Lakes, H-Res 131 also calls on the government of the DRC to investigate and prosecute its own military forces and citizens responsible for human rights abuses, and to proceed with democratic and security sector reforms, which it has previously agreed to. Anyone else like to be heard of this? Okay, I'd like to now recognize myself to speak briefly on H.R. 1897, and I do want to thank my colleagues for their support of the Vietnam Human Rights Act of 2013. The subcommittee, as we all know, heard from witnesses at a hearing on April 11th that the Vietnamese government continues to violate a broad array of fundamental human rights. The testimony we heard confirmed that religious, political, and ethnic persecution continue, and that Vietnamese officials are complicit in human trafficking. At that hearing just over a month ago, we heard from a sister of a Vietnamese woman who was forced to work in a brothel in Russia with 14 other Vietnamese women. At another hearing last year, we heard about a group of Vietnamese workers who were trafficked to Jordan. In each of these cases, not only did officials from the Vietnamese government fail to help the victims, but they actually cooperated with the traffickers to keep the trafficking operations going. I am pleased to report that following the April hearing and the sisters' courageous testimony, the Vietnamese trafficking victims who were being held in Russia have been freed. But the Vietnamese government must respect the human rights of all of its people, not only those who are fortunate enough to have their human rights violations publicized at a congressional hearing. For this reason, I've reintroduced the Vietnam Human Rights Act of 2013, and glad that the subcommittee voted it out today. The purpose of H.R. 1897 is to promote the development of freedom and democracy in Vietnam. It seeks to do so primarily by stipulating that the United States can increase its non-humanitarian assistance to Vietnam above the 2000 fiscal year levels only when the President is able to certify to Congress that the government of Vietnam has made substantial progress, operative words, substantial progress in establishing a democracy and promoting human rights, including respecting freedom of religion and releasing all religious prisoners, respecting rights of freedom of expression, assembly, and association, and releasing all political prisoners, independent journalists, and labor activists, repealing and revising laws that criminalize peaceful dissent, independent media, unsanctioned religious activity, and nonviolent demonstrations in accordance with international human rights standards, respecting the human rights of members of all ethnic groups, and then taking all appropriate steps, including prosecution of government officials, to end any government complicity in human trafficking. This condition is on increased non-humanitarian assistance may be waived in the national interest of the United States if any such increase is offset by assistance to increased training on Vietnam's international human rights obligations, to support non-commercial rule of law programming, or to support measures to overcome the Vietnamese government's jamming of Radio Free Asia. H.R. 1897 also includes several senses of Congress. Vietnam has announced that it is seeking membership in the UN Human Rights Council, a vote that will be held at this fall's UN General Assembly. Given the Vietnamese government's abysmal human rights record, the bill calls on the Secretary of State to strongly oppose Vietnam's candidacy. The bill also indicates that Vietnam should be redesignated a country of particular concern for religious freedom, pursuant to the International Religious Freedom Act of 1998, and that its tier ranking, pursuant to the Trafficking Victims Protection Act, should reflect the fact that the government is not making significant efforts to eliminate human trafficking. Again, I want to thank my colleagues for their support. Yield to any member. Yes, yes, Mr. Meadows.
Mr. Chairman, I want to thank you for your comments and for highlighting this issue. And I've been in some of these hearings as we've heard the just riveting testimony from so many of the affected families. And time again, the recommendation was that we put forth meaningful legislation that does not just talk about our support for human rights, but really make sure that it is measurable and that it has consequences. I'm hopeful that we will see speedy action on this particular piece of legislation. I was unaware of many of the unbelievable atrocities that were happening until we heard testimony in this very room, and I want to thank the chairman for highlighting it, but also putting forth this piece of legislation that I hope will see an end to some of the unbelievable atrocities that are occurring. Specifically, to have an appointment of a country with the known violations that we have to the Human Rights Committee on Human Rights would be very problematic and would send the wrong message. So I agree and concur and would encourage the Secretary to oppose that until we see significant responses on behalf of the Vietnam government. With that, I yield back, thanking the chairman.
Any other members wishing to be heard? If not, I do want to thank my distinguished colleagues for their participation and support for these bills, and on both sides of the aisle, thank you. And without this markup is concluded, and we are finished.